Canada's new immigration Bill C-12 has now passed its final major stage in Parliament and is waiting for royal assent before it officially becomes law. Once that happens, it is expected to introduce wide-ranging changes to Canada's immigration and asylum system, along with broader border security and enforcement measures. The bill has moved quickly compared with most major immigration legislation. It was first introduced in the House of Commons in October 2025, passed through committee study and third reading in the House by December, and then moved through the Senate over the following months. On March 12, 2026, it passed third reading in the Senate. That means the only remaining formal step is royal assent. Bill C-12 is not limited to one narrow immigration issue. It is a large piece of legislation divided into 11 parts. These parts cover areas such as customs enforcement, drug control, police investigative powers, Coast Guard responsibilities, immigration information sharing, asylum processing, document cancellation powers, anti-money laundering oversight, and sex offender reporting. Even though it touches several policy areas, the sections dealing with immigration and refugee protection are likely to attract the most public attention. One of the most significant changes involves the asylum system. Under the new rules, a person who entered Canada after June 24, 2020, and waits more than 1 year after first entry to make a refugee claim could become ineligible for a full hearing before the Immigration and Refugee Board. Another new rule would affect people who entered Canada from the United States at the land border outside a port of entry and then waited more than 14 days before making a claim. In those cases, the claim could also be found ineligible for referral to the board. People who are blocked from a full refugee hearing may still be able to seek protection through a pre-removal risk assessment. That process looks at whether a person would face persecution, torture, or threats to life if removed from Canada. However, critics have argued that this pathway does not offer the same safeguards as a full hearing. Another major and controversial part of the bill gives the federal cabinet the power to cancel, suspend, or vary certain immigration documents when it considers that action to be in the public interest. These documents could include permanent resident visas, permanent resident cards, temporary resident visas, electronic travel authorizations, temporary resident permits, work permits, and study permits. The public interest grounds listed in the bill include administrative errors, fraud, public health, public safety, and national security. The legislation also expands the government's ability to share immigration-related personal information. This could include identity details, immigration status, and the status of documents issued to a person. That information could be shared with federal departments, provincial bodies, and certain crown corporations under written agreements. For most people who already hold valid immigration documents, the bill does not mean their status changes automatically. The new powers would require specific government orders and are intended to deal with broader systemic concerns. Still, the bill could have serious consequences for refugee claimants, future applicants, and anyone concerned about how these new authorities may be used once the law takes effect.